We finally got more information about that super shady subpoena, and Ron is back to discuss. Welcome to Popcorn Planet. I am Andy Signore with a special Friday follow-up. We got Ron Zambrano back. How are you doing, sir?
I'm good, Andy. How are you?
I'm glad you're blown up in our community. I see you popping up all over. Now the Daily Mail's stealing our, we got you in here and I love it because they're getting you all out there. But to the Daily Mail's credit,
Yeah.
it looks like they've been working on this for a while. Now, full disclosure, shout out there to Without a Crystal Ball, who actually found this out last night before it went to public in the Daily Mail. But you can tell us, you were talking to the Daily Mail about this on Wednesday, correct? So they had been working and knew about this before, I guess, last night, correct?
Yes, that's correct. So the reporter Josh Boswell saw me on your show, and he reached out to me. And on Wednesday around noon, 1 p.m. LA time, we were talking, and he had told me, "Listen, what I'm about to tell you, you cannot reveal until we publish." So, but yeah, everything he was talking to me about these details that he had learned back on Wednesday midday LA time.
And to Ron's credit, I didn't hear, no, none of us heard, but props to Crystal Ball who had it out there last night. Somehow, great minds, people were on it. I guess everybody was looking for this lawsuit. And I guess if you look in that specific time period and do your due diligence, clearly multiple people now have found it. So now that we've gotten this mystery lawsuit, seems to have been figured out, this subpoena came from, for those of you who are unclear what we're talking about, Ron was on last time we talked about this, trying to get the cell phone records from Jennifer Abel. They said they got a subpoena, which also allowed the New York Times to do this as well. Well, we finally now have learned what this so-called case was that everyone's wondering, where did this come from? It was from a case from Vanzan Inc. versus John Doe's 1 through 10. And more people did their due diligence to figure out, well, who's this Vanzan? As we sort of learned out, that was a company of Blake Lively's. As more and more went through the state of California and other sort of filings, it was owned by Blake Reynolds, her married name, as the chief CEO, secretary, financial officer, etc. So it has now been confirmed that yes, this Van Zandt versus the John Doe's is clearly a Blake Lively lawsuit, but clearly was filed without anybody's actual name to skirt the issue and try to get this more secretive. Now, this case is now, I think, already been dismissed, right, Ron? So this has already been filed and done with the date of September 27th in New York. Can you explain now why this is a problem for Blake Lively's team in your mind?
Well, it's an ethical problem. Well, there's a lot of problems. So the optics of this are terrible. This lends to the credence that this was obviously created not with any good faith basis of a dispute between Van Zandt and Doe's. Any lawyer will tell you you do not file a complaint if you don't know the name of the person that you are suing, unless you're trying to protect that person's identity for some reason, which if you're pissed off enough to sue them, you probably don't care about their identity. So that's red flag number one. Red flag number two, the context of the complaint are almost nil. It's like there's no really actual facts. And which you have to put something. It doesn't have to be Baldoni level, 600 paragraphs level of detail, but even in 4 paragraphs, you can have some type of understanding like, oh, okay, this happened between these two people, and there's a dispute about this specific thing, and no one has to guess as to what it is. And also that there are no does, and this was done this quickly. I don't know how fast things work in New York, but once you put something in the system, in the court system, things are done automatically on their end. For instance, it gets assigned to a judge. That judge gets it. His clerk sets hearings as to manage the case. Where's proof of service? I believe the dismissal of the complaint was in December, just before the New York Times publication. That's my understanding of what it is. Now, it's probably in the article itself, and I spoke to Mr. Boswell, Wednesday, and I could be wrong on the dates, but my memory is that it was dismissed voluntarily by Vanzan Inc. just before the New York Times article came out. Are you looking for it? Here we go.
Yeah, I was trying to find it. It doesn't have the specific day it was dismissed, but our reporters are confirming that too. Yes, this case was dismissed. Unclear when, but from what I gathered as well, right before the CRD was filed in New York from Blake.
So that that lends credence to this complaint. This Van Zandt complaint was created purely with an ulterior motive, which has its ethical implications, if that's true, with regards to the New York State Bar. Probably as Vanzan Inc. probably has some implications. Nobody should be wasting the court's time. There are some serious implications there. And when you file something for an ulterior motive, you're still engaging, I believe, in self-help in the current lawsuit that is in the New York District Court. So there's a whole can of worms that have been opened by this, that this is not over in any sense of the word. I think there's a lot of there's going to be a lot of questions asked by the Manat folks who signed this, who signed off on this, who filed this, and I would not want to be in their position right now.
Well, so it's interesting because now I have questions, because as we have both Brian Friedman and Lively's lawyers have sort of commented on this. Brian Friedman told the Daily Mail, "This appears to be an end around, skirting the process to be able to secretly get these documents without having to give anyone notice. That would be an abusive process, and we intend to take all action allowable under the law." As you're saying, echoing what you're saying, Friedman said he had no knowledge about the lawsuit until Daily Mail contacted him. Now, Lively's lawyers said the newly uncovered lawsuit was common and entirely appropriate, and accused Friedman of faux outrage. So, I mean, look, and that's where I'm at. Like, why would they do this? They clearly knew this could come. They clearly knew by saying there's a subpoena, someone eventually could find that said subpoena. They had to know this could be uncovered. If this is such a mistake and impossible and not appropriate and going to get them in trouble, why would they have done it? Any thought process? What?
So by talking to some other folks, I've learned that there was a confidentiality agreement between Stephanie Jones and Baldoni. So if there is a confidentiality agreement, as most celebrities require the people that work for them or
because she not to interrupt, but yeah, because she was his PR person for a time. Correct. Yes.
If she were to voluntarily give internal communications between Stephanie Jones and Baldoni to a third party, regardless of the purpose of whether being asked for, that would be a violation of that confidentiality agreement and subject her to litigation for violating the confidentiality agreement. So the subpoena would, in theory, insulate her from a lawsuit of violating the breach of confidentiality agreement, because NDAs do not protect anyone against disclosure of unlawful conduct, right? NDAs do not. So for her to go like, listen, I'm allowed to produce these things because I'm being compelled by a court of law under penalty of contempt, then she can say, listen, yeah, I have this contractual obligation to preserve our communications, Justin, but look, I had to. Look, there was a subpoena. But the problem is this: when this was issued, supposedly issued legitimately according to Lively's team, they had to give notice to Baldoni, as he is the consumer that's being affected by this request of documents, which didn't happen. And that is another wrinkle against either Lively's team or the attorneys that were handling this, because that is, again, anyone who does civil litigation, when you look for third-party information, if you believe it affects hospital records, right? I want the defendant's hospital records, the plaintiff's hospital records. I go to the hospital, but I give notice to the patient who happens to be the party. I'm trying to get your records for that person to try to assert their rights. It's the same thing here. And the lack of notice to the consumer, who here would be Justin, is, again, part of this longer thread of not being transparent and not doing everything completely above board.
Well, it's odd because it seems to be the same thing they're accusing Justin of doing, which is shady tactics, untraceable tactics, anything they can do to use their power to shut up and intimidate and get control of Justin Baldoni. It sure looks like that's what Blake's been doing. And it's frustrating, right? Because the date, just 4 days after the filing, they issued a subpoena to Stephanie Jones, who willingly did it because Stephanie Jones had an axe to grind with everybody else. Meanwhile, no one else got the subpoena. That's so strange, right? And then meanwhile, the New York Times, which claims, oh, we're totally above board. And yeah, we saw a subpoena, All these people, it seems clearly now, as more and more things come in line, we're all working in tandem to secretly put this whole thing out, to defame and go after Justin without ever letting him have a chance, or his legal team to have a chance to do anything or respond. To me, does seem incredibly unethical. And I guess that's my question. Legally, is Friedman and Justin going to be able to use all of that shenanigans to prove the point of this is absolute defamation. This was absolutely a coordinator attack at my entire career and identity.
So yeah, that's a loaded thing, and I see how you got to that point. I don't think the New York Times knew about how little the Lively team was working, because again, I've dealt directly with editors and attorneys for the folks at the New York Times, also the Wall Street Journal, the Daily News. These people are very careful. Like, they do not need they don't they're no none of these guys are desperate for hits on the online, and they will ask questions directly, like, is this legit? Did you really serve this? Is this really public information when at the time we're going to publish? And I don't know if I'm defending them, but I will take the stand that New York Times probably asked direct questions to make sure that the Lively team was acting above board, and that Lively, back to the New York Times, said something or omitted something, or massaged something to convince the New York Times to do what they ended up doing. That is my position. Now, as far as what Baldoni's team can do and Friedman's team to do, what they could do is they could take all of this and do and work towards trying to disqualify Manat from, because they were part of that lawsuit, I believe.
Yep.
Disqualify Manat from continuing to represent Lively in the litigation because of the self-help and their conduct prior to the litigation, leading up to it. It is clever. It is wily, but it is completely unethical what they did, because this is the thing. In that lawsuit, what is the communications between Stephanie Jones and Baldoni regarding the film have to do with Vanzan's lawsuit? Nothing. It has nothing to do with that lawsuit. And if Friedman really gets this stuff and starts poking through discovery and depositions and putting people in corners as to timing, he can possibly get a very good motion before the federal judge about disqualifying the case. And then the other thing is, we still don't know if this existed before or after she handed over the phone. We don't know when the phone was handed over.
Yeah, another valid point. So yeah, I mean, again, all Blake's side keeps saying, well, don't forget they were going to bury everyone. It's like, to me, the more we learn from Blake, I'm like, you're doing the same thing. You're doing all these weird, untraceable, crazy, weird things that you didn't want to get caught doing to basically skirt around the law. Which to me, it's like, oh, and I'm not even accusing Justin of doing that. There is a text obviously that says, these things, but the text doesn't mean they did it. But now we're seeing Blake actually do it with these sort of shady tactics. Is that going to affect a jury? Like, if they just remove the team and the lawyers, that seems almost like a slap in the wrist. I know that's a big deal, but they'll just bring in new lawyers. They'll move on. Does a jury and the judge get to sort of see, oh yeah, you're not acting above board? Can that affect them in a verdict?
The Baldoni will ask. I think what will happen is, leading up to the trial, every party is going to ask the judge to what's called make sure certain pieces of information never get revealed to the jury. It's called motions in limine.
Yep.
And I believe this topic is going to be one of many topics that Lively side is going to ask the judge that this can't even come up. No one can be asked about this. No one can be asked about the prior lawsuit. But the problem is that the prior lawsuit is what brought Stephanie Jones's text messages to the CRD complaint. So I don't think they're going to be able to get out of it. At least this particular existence of the prior complaint, because what I would do if I were Friedman, among many, many things, but on this particular thing, when I get Blake Lively's deposition, that's probably, I don't know if it's going to be the first, the middle, or last thing I'm going to ask, but I'm like, let's talk about this Vanzan lawsuit. What was this about? When did you first think about filing that? When did you retain counsel? Were you consulted in the subpoena? Did you already talk to Stephanie Jones before she gave you the phone? These are all these questions that I've just brought up. I'm sure everybody's going like, yeah, we'd love to ask that. Well, he's going to find that out. And the first person he's going to ask that to is Blake Lively during her deposition, which I imagine will probably last the full 7 hours that you can take in a federal case.
That's the Mac. Interesting. And so but are they they're going to stall that as long as possible to get to that deposition, I imagine, right? What is the tactic there on Blake's side? Is there a point
She's
where
on
we'll
a,
even get there?
oh yeah, for sure. She'll be compelled at the end of the day. They'll try to, I mean, she's a party to the case.
Right.
They can't protect her from it. The only thing they could do is what typically when you have people that have celebrities, people that are very recognizable, their lives, are just out there, and anything negative can really impact them when it has nothing to do with anything. What we do is we enter into what's called protective orders with regards to discovery, that nothing that's revealed between the parties, like depositions, can be published in any way or revealed before it goes to trial. That's the best they can do. But outside of that, she's going to have to testify, and the judge is not going to let Lively Steam play around with her availability. Like she's busy, she's on, I don't know, she's on a book tour.
She won't be able to do what she did to It Ends With Us Wayfarer team.
No.
Exactly. Blowing off all the shows to go to Taylor Swift
No.
concerts. So we will see that
Absolutely
deposition if it goes to trial and it's recorded. That does become public release.
No. So if there's a protective order in place regarding discovery, then it cannot be released to the public before trial, but unless it's shown at trial. So once it's shown at trial, it's available to the public because anyone can sit there and listen. But if the protective order is entered into and agreed to by the judge, and the parties have to be subjected to it, or subject to it rather, then it would be a violation of that order to reveal anything outside the parties, the attorneys, really.
Right, but if it becomes part of the trial, then it is a public property.
Absolutely, yes. Yes.
I'm sure people are curious. And last thing while we're here, because it's like all of this is so related and so important, because these text messages that they got, which now they use this weird fake subpoena to do, omitted things. Who actually gave what text to who becomes the big question, right? Because New York Times is saying, well, we just published what we were given, and then Jones Works, and there's Blake's team. Like, what is your suspicion? I mean, we all assume, they were all working in tandem and it was all sort of crooked, or Blake's team was overseeing it. But from your sort of legal fair perspective, I mean, isn't it strange that Blake's team didn't put the full context in? Do you really think there's a version of this where they didn't go through it all with a fine-tooth comb before publishing it? Wouldn't they have been the ones that pick and chose which ones came through?
Yeah. Yeah. So that's not really a legal thing. That's a tactical thing. They made this tactical decision to omit things, and I think we discussed it right before we came on. I believe that Lively did this the way she did the Civil Rights Department complaint. That's supposedly confidential, and she put it out, everything in there. I really think she picked this fight through that mechanism and process in order to anticipate a backlash and her asserting the privileges that we are now seeing. But it was not well thought out, and it's not an absolute privilege, and you cannot abuse the legal process. So the problem for Lively's team is we just found out about an initial abuse of the legal process, a misuse, let's call it a misuse of the legal process with this Vanzan complaint, and then the Texas thing that happened. So I think she thought she was going to get away with this and have these protections, and it has not worked out. And I don't know who told her this, but she did not, or her team did not think this through by omitting stuff, because whenever you omit stuff, the other person has the whole thing. They have the whole thing. Like, you don't be stupid. You can't just delete stuff and go, look what I have. I'm like, yeah, I have the rest of it. Look, like it's like a no duh. It's crazy.
This whole case has been crazy, and I appreciate you, Ron, for being here. Always love chatting you. I'm glad to see you out there. We will keep you posted as more updates. Thank you for making the time. Also, if you didn't notice, I'm wearing the shirt. That's right. The shirt's now out. You can become an investor too. Head on over to the store. In fact, you'll see the little logo right here. I'm going to put up the end card. Click on that little end card right there, the shirt logo, become an investor. You'll get your name in the project. Ron's in the doc. Kirsty's in the doc. So many crew members are in the doc. You're going to want to be a part of this. Click it over there. Support it. Stay tuned. We got a lot more coming your way.